Welcome to the Legal Lines. Today my guest is attorney Dawn Cutaia of the Cutaia Law Firm, and we are going to be talking about juvenile law. My name is Tom O'Shea. I am the host of the show, and this show is brought to you by the York County Bar Foundation. Dawn, turning to you now. Today we will be talking about juvenile law, and as I understand it, there are two main categories of juvenile law: juvenile delinquency and juvenile dependency. And can you explain the distinction between the two?
Sure. Both the juvenile dependency and juvenile delinquency statute is in the Juvenile Act. And just briefly, the differences between the two is delinquency is where a child has committed a crime. And it deals with how that case proceeds, the procedure of it, and then what happens if that child is found to have committed the crime and what their disposition should be. Dependency is where a child is either without proper parental care. For example, a parent is unable to care for the child, whether it's because of drug abuse or they're in prison or some other reason, or because the child is out of control, running away from home, truant, and they need to have the state, Children Youth Services, step in and make sure that they can kind of get back on track.
Okay, and let's focus a little bit then on juvenile delinquency first, and we'll talk about juvenile dependency. You said that juvenile delinquency is typically when a minor commits a crime.
That is correct.
Oh.
But it is different than the adult system in many ways. First of all, the age of the child is relevant in determining whether or not a delinquent act has happened. The definitions of the crimes are the same as they would be for an adult. So, an assault for a child is the same as an assault for an adult. But when a child is involved, the court has to look at their age first to determine whether or not that child should be treated as a dependent child, a delinquent child, or treated as an adult.
Is that based upon age?
It is based upon age and also based upon the type of crime. So the first thing is that if you are a child that is under the age of 10, then regardless of what crime you commit, you can't be delinquent because you're so young. So that's one of the rare instances where dependency and delinquency kind of merge, because the statute says that that child is dependent, and then Children Youth Services would deal with how to take care of that child and help that child, and they won't go through the delinquency system. The general rule is that if you are over the age of 10 and you commit a crime, then you are going to go through the delinquency system. If, however, you are over the age of 10 and you commit more serious crimes, then you could actually have your case moved to the adult system. And I said over the age of 10, really it's over the age of 12 and above. So if you commit, for example, an aggravated assault or rape or something serious of that nature, robbery, then the Commonwealth of Pennsylvania, the prosecution, the DA's office, can then move to have your case removed so that it's in adult court.
Would there be a hearing on that in front of a judge, and ultimately the judge would determine whether it's a juvenile case or an adult case?
That's true. What can happen is, depending on the type of case it is, either the DA can initially file in the adult criminal court, and then the child can petition the court to have it decertified to go back to the delinquency system, or it can happen, later on in the proceeding. Now, murder is always charged as an adult, whereas these other crimes may or may not be charged as an adult. I've had clients who have been charged with aggravated assault, but they're not necessarily charged as an adult. There are some other requirements in order for a child to be charged as an adult. For example, aggravated assault and rape and those other serious crimes, they have to either have a deadly weapon with them, or if they've been adjudicated delinquent before, then they can be charged as an adult. So it's not necessarily an automatic thing except with murder. If the child wants to have it come back to delinquency court, then he or she has the burden of proving that it's in the public's interest to have that case go back to delinquency court. And the difference between delinquency court and the adult system, in theory, is that delinquency court is not about punishment, it's about rehabilitation. And so one of the things that the child might be arguing to have the case go back is, I can be rehabilitated, I can, contribute to society. And it's just a different type of system in the adult system. Yes, we care about rehabilitation, but there's also punishment there too. In theory, there's not supposed to really be punishment under the delinquency system, which is why kids can't go to jail. There are different things that can happen to them if they are found to have committed the crime, but jail is not one of them.
And you mentioned a term a few moments ago where you said adjudicated delinquent. Is that after the hearing where they're found guilty, but they don't use the word guilty?
That is correct. The terminology for delinquency is a little bit different than it would be for the adult system. They have a fact-finding hearing as opposed to a trial. Juveniles do not have the right to have a jury. Now, if they're certified in its adult court, then they have all the rights that an adult has, so they would have a jury.
But if they're in juvenile court, then there's
right.
no right to a jury trial.
That is correct.
But other than the right to a jury trial, are all the other constitutional safeguards put in place?
That is correct. Juveniles have the same right to remain silent, the same right to an attorney. If they can't afford one, then the county will pay for one for them, either through the public defender's office or a court-appointed attorney. In addition, the Fourth Amendment rights that they have against unreasonable searches and seizures, all of those rights are the same for adults as well as juveniles. And going back to the procedure of it, after the fact-finding hearing, then the judge has to make a determination as to whether or not this child has committed this crime beyond a reasonable doubt, just like the jury would do in an adult case. And they don't call it guilty. They say that the child has been adjudicated delinquent. And if a child has been adjudicated delinquent, then the next step is going to be sentencing, which is not called sentencing. It's called a dispositional hearing. And so all the terminology is different because, again, delinquency is about rehabilitation. And so they just don't use those terms, I think, because it's really not a finding of guilt. It's just, we're going to try to help you kind of get back on your feet. Disposition in a delinquency case might be something as simple as probation. In addition, sometimes the Commonwealth might offer something called a consent decree, which is very similar to what ARD is for adults. So in the adult system, if you commit a misdemeanor crime, something like DUI, another misdemeanor, maybe harassment misdemeanor, and some more serious crimes, you would get ARD or on probation, you pay a fine, and if you don't violate those terms within a year, your case is dismissed and your record is expunged. The consent decree is very similar to that. It is completely within the DA's discretion whether or not to offer the consent decree. There's also informal probation, which is really, no admission of liability, and you're just kind of on probation, and if you do everything you need to do, then the case would go away. And then there's formal probation, which is very similar to the adult system. You meet with a probation officer, you have to pay any restitution, pay court costs, do a victim impact class, you might have drug tests and so forth, counseling and things of that sort, depending on how serious your crime was and really how at risk you are for reoffending. What's your family situation and so forth.
You mentioned something about a juvenile or the record. So does this become someone's permanent record if they were juvenile and they were adjudicated delinquent?
Yes and no. The records regarding juveniles are closely guarded, and it depends first on the type of crime that a child has been adjudicated on, as well as the age of the child. Misdemeanors are never open to the public. So if a child's been adjudicated on, a trespass charge, even, a small amount of marijuana, underage drinking, all the things that are misdemeanors, simple assault, that would always be sealed and no one would really have access to that. And I say no one, I mean the general public. However, if a child has been adjudicated of a felony and the child is over the age of 14 and their case has not been sent to adult court, this is if they're in delinquency court, then there is some public access to that. The public has access to the name, the age of the child, the charges, and the disposition. The effect of that is an important one that I think a lot of parents don't understand, because in addition to the public having access to the record, they also, that felony counts as a prior record score for the defendant or the child if the child were to violate as an adult. So let me explain that. When you are an adult and you commit a crime, you, depending on what kind of crime it is, you get a point on your prior record score, and that's your rap sheet. and the more points you have, then the next crime that you commit, you're going to face a stricter penalty. So whereas if you had a 0 prior record score, you might just get probation. If you have a prior record score of 5, you could go away to state prison for the same crime. What a lot of parents and kids don't realize is that as a juvenile, if you're over the age of 14 and you are adjudicated of felony, you will get 1 or 2 points on your prior record score. And those points will follow you into adulthood. And so if you commit a crime as an adult, that could make a big difference as to whether or not you go to jail or you just get probation. And so, not to be cynical, but parents really need to understand that this is not necessarily an opportunity for you to teach your child that they did something wrong by getting them to talk to the police. If you want to deal with it at home within your family, that's one thing. But if you are encouraging your child to talk to the police, if they're adjudicated of this felony, that's going to stay with them for the rest of their life, unless they get their charges expunged, which we can talk about. But
basically what you're talking about here is the Fifth Amendment right to remain silent.
That is right. And so
sometimes parents don't stress that with the child, which a lawyer would pretty much stress to a client.
That's right. And I think it's because, parents are trying to teach their kids a lesson. And when the police come to interview the child and they ask the parents, because they have to get the parents' permission, is it okay for you to talk to our child? And I've seen it happen with my own clients. The parents have told the child, before I'm involved, you need to talk to the police. You need to tell them what you did. But this is not just a learning experience. This is real life. And these kids could be seriously negatively affected later on in life if they're adjudicated.
When the juvenile is being interviewed, do the parents have the right to be present?
Yes, the parents should be present, and in fact, they're supposed to be present when the juvenile is being interviewed.
And the same thing with they have the right to an attorney as well.
Once they're sort of considered a suspect and they're not really free to leave, then the police are required to read juveniles their Miranda warnings, just like they would anyone else.
Including the right to probably cannot afford an attorney.
That's right. And so then they would be entitled to a court-appointed attorney.
Even if their parents had the ability to pay, are the parents required to pay for the juvenile?
It depends on the county. Some counties will allow the juvenile to apply kind of on their own income, and some will not. My understanding in your county is that they will represent juveniles regardless of the parents' income. And so juveniles should always be encouraged to apply to see whether or not they do in fact qualify. Obviously, they're free to hire a private attorney if they want to do that. There is a case that just came down actually from the Supreme Court of the United States that I do not remember the name. But
no, before you get into the case from the United States Supreme Court, we only have a few seconds left right now. So I would like to thank you, and we will be back after this break. This is Legal Lines. My name is Tom O'Shea. My guest is Dawn Cutaia. Welcome back to Legal Lines. My name is Tom O'Shea, and my guest today is Dawn Cutaia of the Cutaia Law Firm, and we are talking about juvenile law. And right before the break, you started mentioning a United States Supreme Court that came down very recently, and I understand this case deals with both adults as well as juveniles, but what is this case?
That is correct. I don't remember the name of the case, which is sad since it only recently came out, so I should remember it. But it basically puts a higher burden on defendants and juveniles who are charged as well about their Miranda rights and their right to have an attorney represent them. It was that, they would read your rights and then you just had the right to remain silent, and the police were not allowed to continue to question you or anything like that. This new decision says that you have to affirmatively say, I want an attorney, I don't want to talk. And so it just puts more of a burden on defendants to make sure that they're affirmatively saying what their rights are, and it doesn't to prevent the police from continuing to try to talk to them or anything like that. So it really kind of erodes some of the protection that that people had before.
Now I understand that this is a United States Supreme Court case that came out of another state, but the Pennsylvania courts may decide not to accept this standard because they're allowed to have a higher standard than the federal system, but not a lower standard.
That's right. That's right. Everybody kind of knows, oh, the federal government, the United States Supreme Court trumps everybody, and it does in terms of that's the minimum threshold of what you have to do to protect a defendant's rights. Pennsylvania can provide more rights. And so Pennsylvania could say, no, we're not going to go with that. We think that that burden is too high for defendants. And the courts have done that in Pennsylvania with search warrants and so forth. They've actually held the police to an even higher standard than the U.S. Supreme Court has.
Okay. So, but getting back to mainly juvenile law, I think one of the things we need to point out in a juvenile delinquency hearing, are they open to the public?
If they're over the age of 14, if the child's over the age of 14 and has been charged with a felony, then yes, they are open to the public.
Okay, but if the child's under the age of 14, it's a closed hearing.
That is correct.
So,
and if it's a misdemeanor, it's always closed.
All right, so even if the child is 17 or...
Yes,
yeah, okay.
Yes.
All right, and just to be sure, what age does being a juvenile end? Is it 18?
It's 18, however, if you're adjudicated before your 18th birthday, you stay under the juvenile system until you're 21 for that crime. So, for example, they can still send you to placement. Let's say you have probation and you violate your probation, not with a new charge, but maybe something else, running away from home. They can then keep you in the juvenile system and send you back into placement or something like that. So even though you turn 18, their supervision doesn't end until it ends. In other words, until they're done with you or you turn 21.
Okay. One of the other things you mentioned is that we really haven't talked about much is expungement. If somebody has a juvenile record, can it be expunged?
It can be. You can petition for it to be expunged. This is a big difference than the adult system. The adult system, it is extremely difficult to get a record expunged, and you have to be, I believe the statute says 76 years old. Adults can ask for a pardon from the governor, but juveniles can ask to have their record expunged. They have to be 18 years or over 18 years old to do that, and they just file a petition, and they have to show, why it's important for their record to be expunged, if it's preventing them from maybe doing something, they want to get into the military or something along those lines, and so it's important to have this gone. They obviously have to have led, a crime-free life since they were adjudicated, followed through with their probation, kind of did everything they needed to do, and then the district attorney's office can oppose it, but the judge has the ultimate say as to whether or not it gets expunged.
Now, would this be something that can still be done as a juvenile, or do you have to wait till you're an adult to seek?
You have to wait till you're over 18 to seek expungement.
All right. Well, the other topic that we were going to discuss under the juvenile law is juvenile dependency.
Right.
We were talking mainly about delinquency. Now, delinquency is when a juvenile is accused of a crime. Dependency could be no fault at all of the juvenile. It could be a very young child, for example, who doesn't have parents who are capable of taking care of the child, so the child could be adjudicated dependent.
It's not adjudicated. It's just found dependent.
Okay. So I'm using the wrong terminology. Okay. But that's so. Could you tell us exactly what goes on with a juvenile dependency? I gave an example of where the parents are unable to take care of the child, but there are other areas where dependency takes place. Am I correct?
That's right. When you have dependency involved, that's Children and Youth Services generally. Is the agency that's involved, not the prosecutor. And there are various ways that a child can be considered to be dependent. One would be the one that most people know is that there's something that the parents are not doing to take care of the child, abuse or drug abuse by the parents or something along those lines. And the legal term is that the child is without proper parental care or control. So
it could either be abuse or neglect.
That's right.
The parents
abuse
aren't doing what they need to do to take care of the child.
That's right. Or they're not capable of taking care of the child. So it could even be that, a parent has become so sick that she can't care for her child. She hasn't done anything wrong, but she just can't. She doesn't have any family or anyone else to help her. The state would have to come in and declare that child dependent. No one's done anything wrong, but the state has a responsibility to make sure that children are protected. Children can also be found dependent because they are habitual, runaways or habitually truant. Now, parents can get in trouble for children being truant, but if a child, usually you see this with teenagers, they're just refusing to abide by the lawful commands of their parent, then if a parent says, I can't control her anymore, they're running away from home, they're doing drugs, they're skipping school, I can't handle them anymore, you take them. And so the agency can step in then, and will step in even if the parent doesn't want them to, and then attempt to remedy that situation. Depending on how severe it is and what the situation is at home, the agency might ask for the child to be placed in a foster home or even a facility similar to what a delinquent child would go to, but a little bit less strict and more sort of geared towards counseling and that kind of thing. And there are numerous places like that. Or if a child has serious maybe mental health issues that aren't being addressed at home, so they might go to the Meadowlands or Philhaven or one of those kinds of places to get the treatment that they need. So those are various reasons why a child could be considered dependent. Now, when the agency gets a referral...
How do they get these referrals?
Well, there are some people who are mandatory referrers, like, for example, doctors and that kind of thing. If a child's brought to the emergency room and the doctor examines her and she says, okay, this child has been beaten, and so then the doctor, she has an obligation to contact Children's Youth Services, and if she doesn't, then she's in trouble because she's a mandatory reporter. But sometimes people make referrals, you might make a referral about your neighbor or something. And sometimes people make referrals just to be mean that have no basis. And the agency has to deal with trying to weed out those referrals.
Mm-hmm. As I understand it, many times it's parents in custody disputes
right.
who are alleging the other parent is doing something wrong.
That's right. And the agency gets a lot of those referrals that they have to, and there's always sort of, they have to be careful. They don't want to, disregard something that's legitimate. When they get that referral, they can file a petition for emergency placement. There has to be a hearing within 72 hours, but they can just go in with the police and take that child from the home. It's a pretty high standard. They have to have some serious reasons why they think that child is in immediate danger, being physically abused, being sexually abused, something along those lines, to go in and take that child. Because obviously, parents have significant rights, especially in Pennsylvania. And the next step then would be, after you have that hearing for emergency placement, the judge is just making the determination as to whether or not the child is going to stay in placement. Then the agency would then file a petition for dependency, alleging the child is dependent for whatever the reason is that they're saying he or she is. They don't have to file the petition for emergency placement. They can just file the petition for dependency if they want, and then proceed from there. The judge then would have to make a determination as to whether the child is truant or has, run away, or the parents are abusing the child. And it can be entered into by agreement that the child is dependent, or there can be a full-blown hearing. The parents are entitled to court-appointed counsel if they can't afford a lawyer, or they can hire their own lawyer. And the children get a guardian ad litem. The guardian's job is to communicate to the court what the child wants, but also give the guardian's recommendation as to what he or she thinks is best for the child. And it doesn't matter if they're different, if it's different than what the child wants.
So if you have a 16-year-old runaway who says, I want to continue to run away, right, and I should be innocent of anything, and right, I shouldn't be in placement, the attorney might say to the judge, well, this is what my client wants, but I think it's in the best interest of the child, right, that there be some type of restrictions or placement for the child.
That's right. And that is very common, really, with teenage girls, because they'll say, I want to go home, I promise I'm not going to do this again. And as the guardian ad litem, it's our, the attorney's job to investigate.
Well, that's a good point you bring out. Is the guardian ad litem an attorney?
It is required that the guardian ad litem be an attorney. Now, there are court-appointed special advocates, the CASA office, which is always looking for volunteers. They are volunteer people who, you don't need any special degrees or anything, you do get training. And there's the caseworker from the agency, the guardian ad litem, and then the CASA, whose job is to kind of, do some extra legwork, go out, meet with the child and that kind of thing. And then they get to come to court and give a recommendation as well. When the agency gets involved, when they take a child, their goal always initially starts out as reunification of the family. The Children's Youth Services is not supposed to be an adoption agency. They're supposed to be an agency that keeps families together and tries to get them back together. And in order to do that, they need to develop a family service plan. And that plan is reviewable by a master, which is an attorney who's been appointed by the court to kind of act as a mini judge. And in addition, then they also have hearings in front of the judge as the case is progressing to make sure that the family is meeting their family service plan goals and that the case doesn't get lost. We kind of, because now this child's away from home, we want to make sure we're moving.
I want to talk about that a little. We only have a few minutes left, but you have been using the word placement frequently, and this is what happens to a juvenile. They get placed. What is placement?
Placement could be foster care. Placement could be placement with a relative. It can also be even a neighbor can come forward and say, I'm willing to care for this child. And a placement could also be a residential facility.
It's my understanding, and I don't practice in this area, but generally the court will look for the least restrictive type of placement?
Yes, they're supposed to try to find something that is going to protect the child, but obviously make sure that it is the least restrictive.
So many times it would be a relative, a grandparent, or an aunt or uncle who would be able to take care of the child if the parents aren't able to do so?
Right, and they're supposed to look for other relatives, the agency, to see if there's other people out there who can care for the child before putting the child with strangers. Now
strangers, you're talking mainly of foster parents?
That's right.
And that would be the level above relatives?
That is correct.
Okay, which would be a level below some type of placement facility or juvenile hall or whatever it might be called. I don't know what they're
That's
even
right.
called. What are they called?
Well,
now?
I mean, there's places like Phil Haven, Meadowlands, Mission Home Ministries has like a day treatment center, like alternative schools that kids might go to, depending on how severe their issues were. And
we're just about out of time right now, so I'm going to cut you off there. Our show is Legal Lines. My guest today was Dawn Cutaia. We were talking about juvenile law, and we were brought to you by the York County Bar Foundation. Thank you.